Here's a real property hypothetical that shows us exactly where the law of property touches the law of torts. Take a look at the call of the question. This is an elaborate call of the question which turns this question really into a series of short answer problems. Question 1. Vibrations from the plant have caused unstable soil conditions on the portion of Phil's land that he irrigates and farms, resulting in localized landslides and damage to the irrigation system. It's clearly a question about lateral and subjacent support, and it's also a very straightforward question. There's not a great deal of rigorous analysis involved. We've just got to hit the facts, connect them to the law, and move on. Question 2. Noise and fumes from the plant prevent Phil from converting another portion of his non-leased land into a vacation home subdivision. Clearly, this is a question about nuisance, because the plaintiff is alleging a problem with the use and enjoyment of his land. Question 3. Dolomite is cutting large trees on the leasehold for firewood, which it uses as fuel for its plant's furnaces. This is clearly an issue of waste. It might also be an issue of trespass causing severance. Then finally, question 4. Dolomite is using increasingly heavy trucks, which are destroying the access road through the non-leased portion of Phil's property. This would be an excessive use of an easement, where we've got a party that has a right to use an easement over another party's land. The party with the right to use the easement has to keep that use within reasonable boundaries. And so a use that would actually destroy the road would be excessive, and a plaintiff would be entitled to enjoin that use and to compensation for the damages. And then we get the call of the question, what rights does Phil have against Dolomite, and to what relief, if any, is he entitled? Discuss. Well, it looks as if this is a straight torts question involving land, but it turns out to be a real property question involving a lot of torts issues. And the reason why that is true is found in paragraph 1. The relationship between Phil and Dolomite is that of landlord-tenant. It isn't as if Phil and Dolomite are occupying adjacent portions of land where they are separate landowners. Here, Dolomite is a tenant of Phil. And so in paragraph 1, we get a look at the lease between Phil and Dolomite. And we see that it is a mineral lease for exploration, development, and production. And we also see that this contract expressly provides for an easement across the non-leased land. So here we've got a fact pattern that is testing us on principles of real property, contracts, and torts all at the same time. And really, the reason for that is because here we see they're really all the same subject. What we're dealing with here is civil liability, and a plaintiff pursuing a defendant has to have one or more theories of liability and one or more prayers for relief. And here we see that the relationship between these parties is founded in contract. The subject matter of the contract is real property, and other issues arising between these parties come out of the law of torts. So we're here in the big universe of civil liability. The plaintiff has to have theories and prayers, and the defendant is likely to have at least some defenses, both to the theory of liability and to the prayer for relief. So we go to paragraph 2 of this very short fact pattern. You'll notice that the call of the question is about as long as the facts themselves. In paragraph 2, we learn about Dolomite tunneling underground, which we would expect them to do in a contract that calls for exploration. But then we see that they are engaging in processing. Well, that's a word that we don't see in the lease agreement between the parties. Is processing going to be considered the same thing as production? That's a good question, and it's an open question as well. Then in paragraph 3, we see that Phil has recently complained to Dolomite about its operations in general and has demanded that Dolomite dismantle its processing plant and move it somewhere else. And then we've got the plaintiff's 4 problems. Well, this is really quite a subtle and interesting problem, and it's also quite a difficult problem. Not only because these issues are fairly complicated, and the complexity arises in part from the fact that both parties really do have fairly good arguments, and it also presents problems of organization and time management. We can imagine a fact pattern like this appearing on the multistate with a number of questions following it. But to answer a question like this as an essay, even in the most liberal of jurisdictions, liberal being defined here as the amount of time given to write an essay answer, even with an hour to write an answer to this question, one would face fairly severe time constraints. So turn the page and take a look at the outline of issues that I've presented. Once again, we see just how important it is to organize our thoughts before we begin writing. Many people will pass or fail an individual essay based on how they organize their answer. The better organized your answer, the more thorough it can be, and the more time you have for good analysis. So take a look at the outline of issues and notice that I have split it into two broad categories: the theory of liability and the prayer for relief. Now, it would be possible to engage, just chronologically go through and discuss the remedies right along with the rights. That would be an entirely acceptable way to outline this question too. I've chosen to do it this way because I believe I could write a more thorough, a more detailed answer organizing it this way. Often, there's no one right way to organize an answer. So if your organization differs from mine, but your coverage of the issues is more or less the same, at least similar, you're doing fine. So let's take a look at the outline that I've presented. We are considering the different theories of liability. Within the theories, I go chronologically. I talk about the problems with regard to subjacent support, and I consider it an issue of, potentially an issue of nuisance, and also a possible violation of the lease, depending on whether production and processing are deemed to be different things. Now, although I sort of consider myself as having a bias in favor of the defense, having always worked as a defense lawyer, I have to say here that the plaintiff looks to have a fairly strong case ultimately. So we consider the vibrations and the subjacent support. Next we turn to the noise, the fumes, and Phil's planned subdivision. And here the issue is nuisance. And here the parties both have fairly good causes to argue, because you can't think of a better example of coming to the nuisance than Phil trying to plan a subdivision on property that he already has broken up to lease to a big corporate user of the land in a non-residential manufacturing context. So I am somewhat less sympathetic to this nuisance claim than I am to the subjacent support action. Next, the plaintiff has a strong case for waste or perhaps trespass causing severance with regard to the defendant's act of cutting trees for fuel. That goes well beyond what this tenant should be allowed to get away with, and here the remedy, as we'll discuss below, will be a damages remedy. Next, we turn to the overuse of the easement. Here again, this is a simple claim, and it doesn't require a great deal of analysis. And in fact, I don't even think it requires that much law knowledge. We could get a bunch of smart high school kids together and ask them about this situation, and although they probably wouldn't use precise legal language, I think they could pretty much all recognize that it isn't fair for a tenant to be allowed to use a road to the extent that the road is destroyed. So we consider the various defenses that might be offered by the defendant. Ultimately, the defendant's argument is that the plaintiff leased this land knowing how the land would be used, and as a result, the plaintiff really shouldn't be complaining about it at all, so long as the defendant is cooperating and acting within the terms of the agreement. And as a defense lawyer, my argument would be that the plaintiff made his lease with this defendant, and since the defendant, at least according to my allegations, isn't breaching the lease, the plaintiff ought to shut up and go home. And you know what? Depending on how the facts played out in court, that might actually be the result. But it seems to me that given the facts as they are presented to us, it's likely that the defendant will lose more or less across the board. The plaintiff has at least managed to state valid theories of liability. Now, let's consider Part 2 and the remedies and see how they would play out. With regard to the plaintiff's claim for damages, and here the plaintiff's claim could be turned into damages across the board. All of the different theories of liability ultimately could be monetized. Clearly, that's not what the plaintiff wants, but a court doesn't have to use equity powers, and sometimes a court feels that they can't use equity powers. Under those circumstances, a plaintiff is limited to dollar damages. Here, the damages would be measured based either on the diminution in value or the cost to repair. Next, we turn to what the plaintiff really wants, which is injunctive relief. Are legal remedies adequate? Answer, no, because the interests that are being litigated here all involve land. That's true in land sales contracts, and it's true in essentially tort theories of liability, which these are, with regard to the harms caused by the defendant's actions. Are property interests present? Sure. There's no clearer-cut example of a property interest being present than a dispute involving land. Is it feasible for the court to present an equitable remedy? Answer, yes, because the court has got personal jurisdiction over the parties and in rem jurisdiction over the real estate involved. Now, balancing the hardships. Here again, this is where the defendant may have a fairly compelling argument. We don't know a lot of facts that would be helpful in balancing the hardships. For example, we don't know how big an employer Dolomite is. We're not aware of the economic impact on the community of this business's existence in the community. All we know about is the harm that's being caused. And we know that principally one person, Phil, is suffering this harm. So, in balancing the hardships, particularly with regard to a dispute involving land use and involving broader community interests, here those community interests would be defined as the defendant as an employer and also the broader community concerns in pollution and in having an environment that is safe and healthy. Well, we don't know enough facts to really balance the hardships well. But based on the facts that we know, the hardships might well balance in the favor of the defendant. So we can judge the issue with a fair amount of wiggle room, but ultimately I would conclude that the processing plant has to be either shut down, moved, or modified in some way to limit the harms that are being caused to the plaintiff. For sure, the defendant will be enjoined from cutting further trees and will have to pay damages or perhaps even replant trees that have been cut. With regard to the road, the defendant will be liable for fixing it and for maintaining it properly and will have to use trucks that won't destroy the road. So that concludes an analysis of a complicated, difficult real property problem that ties together real property, torts, and contracts. Once again, I think you can see clearly that the best way to learn how to handle tough questions like this is by practicing hard questions like this, rather than merely studying.